Recreational Holdings and Lazarus.
You sit down.
My Lords, may it please, in this matter I appear together with Dr. Lloyd Barnett, Mr. Whedon Daly on behalf of the appellant, and my learned friend Mr. Alan Wood, QC, and Mr. Midwell Williams here for the respondent. My Lords, you'll have seen this an appeal against the order of the Court of Appeal made on the 30th of Jamaica, made on the 30th of September 2014, dismissing our appeal against the order of Mr. Mr. Justice Kirk Anderson on the 20th of September 2012, which in summary declared that the respondent was entitled to the disputed strip, which is 8.92 acres in the parish of St Thomas, and ordered damages to be assessed. We say that order was wrong. The Court of Appeal should have dismissed or made an order dismissing the respondent's claim and upheld our counterclaim and also in our claim in the fixed date action on the basis that we were a bona fide purchaser for value of the disputed strip, who therefore took free of the respondent's claim by way of adverse possession. My Lords, there are three...
Well, we've been very helpfully supplied with two very full and helpful written cases, and we've read them, and we have on board the points at issue. Sorry to interrupt.
Not at all.
I should say that.
My Lords, there are three main issues in my submission. The first is on a proper construction of the Registration of Titles Act and Limitation of Actions Act, and leaving Chisholm and Hall on one side, is a bona fide purchaser for value bound by rights which a squatter has acquired against the vendor.
Bona fide purchaser for value without notice, or bona fide purchaser full stop?
Bona fide purchaser for value.
For value, but nothing about notice.
No, you don't have to...
It seems to me to follow
yes.
from what you say. Yeah. Okay.
So the first is leave Chisholm Hall on one side is the bona fide purchaser for value bound by squatters' rights acquired against the vendor. Yes. Second issue, if, on a proper view, the bona fide purchaser for value is not bound, should the Privy Council nonetheless follow the observations or the ruling in Chisholm and Hall? Or should it depart from that ruling or those observations?
Yeah.
I'll come to the question.
Well, that's a slightly perverse way of putting it, isn't it? I mean, whether Chisholm and Hall is right is really integral to the first question.
It is. But what I need to satisfy you of first is that I'm right just looking at the statute cold and then coming back to Chisholm and Hall.
It's hardly likely we're going to decide that the statute means X, but it's been held to mean Y previously, and therefore it must mean Y.
You might think, on the one hand, that I'm arguably right, and my Lords, I envisage the possibility that you'd say to yourselves, well, look, if this had been argued clean, then maybe I'd have come to a different conclusion, but I need to uphold a decision even if I think it's wrong. So I do submit the first question.
I've done that. I've been party to doing that in the past, so it is theoretically possible, but it's quite rare.
It is. I think I was a victim of one of the changes of the law, but there it is. My Lords, the third issue, my Lords, the first two issues really run together, but I do need to deal with them as separate issues. The third issue is, if the Board holds that Chisholm and Hall was wrongly decided and should be departed from, how should it dispose of this appeal? In particular, should it order summary judgment for the appellant on the respondent's claim, and enter judgment for the appellant on the fixed date claim, the appellant's own fixed date claim, and declare that the appellant is the owner of the disputed strip, and if not, what order should it make? For instance, should it just order the matter to go to trial? My Lords, there is another fourth small issue, but one which in my submission highlights the problem in the respondent's case, and it's this. Is the respondent in any event entitled to hold on to the order for damages to be assessed? And if so, how and why? Because, my Lords, in a funny sort of way, I submit, once you ask that question, everything begins to unravel, for reasons I shall explain. My Lords, just the structure of my argument, I'm going to make a few observations on the facts. I'll then go through the most important background provisions in the Limitation of Actions Act and the Registration of Titles Act. I'll then make a few submissions as to why the Court of Appeal's judgment produces anomalous results and is contrary to the purpose of the Act, as a general point. And then I will turn to our three main submissions in our written case as to why the Court of Appeal was wrong. Then I'll deal with Chisholm and Hall, and then Dr. Lloyd Barnett will deal with the disposal of the case, and he may make one or two supplemental submissions on Chisholm and Hall. My Lords, dealing with the facts, the first, I should show you the area of dual registration, or the disputed area. Yeah. And if you go to volume 1 of the record, you can see that at page 88. There's a similar map at 85, but it's easier to see it from 87 and 88. And what you can see here on page 88 is halfway up the page on the right, a marked out area which has got references to the two title numbers. And you'll see first, there's a reference to Vol 1204-807. That's Mr. Lazarus's title. And then Vol 1154-550, that's Mr. McGann's title. And you'll see 8.92 acres is the area in dispute. You'll see to the south of that area the Yallahs River. You can see Yallahs on page 87 at the foot of the page and River at the foot of page 88. So that's Yallahs River. And then you can see to the north of that disputed area, running up from page 87 on the left-hand side at the foot, from Mount Parables, you can see you can see a road that takes you up onto page 88. So that's the layout of the land. And you can see some photographs of the disputed area, which were attached to my client's affidavits at page 100. And if I can just tell you what this is, I'll give you the reference in the page as to where this evidence comes from. Page 100 is a view of the disputed property from the public road, i.e. from the north, it would seem. And you get that from page 98. So it's pretty overgrown. Yes. And then you turn to...
Well, that's standing somewhere at the top of the picture, isn't it?
Yes,
Page
yes.
87, where it says to Hagley Gap or something like that.
Yes,
Yeah.
yes.
And the point of looking at this is...
Just see, it's jolly difficult to discover whether anyone's there.
My lords, really, that's the point. It's just to show how difficult it is to see. But my lords, I don't think I need to take you to the other photographs. The only other one I wanted to show was at page 107 and 108.
Thank you.
Probably quite a lot of Jamaica looks like that, or similar to
It does indeed. 107 is the view north, a view from the north where the disputed property adjoins the river. So this is where the property is near the river at 107, and 108 is an aerial view of the disputed property.
On 103 and 104, the buildings that
Yes.
the respondents placed on the land.
Yes, 103 and 104, the two buildings on this. Yes.
Where are they, roughly?
On the disputed land, my lord, I'm not sure, I'd have to check this, that they're actually identified on the plan at page 88.
What is 108? That's looking at, there are some buildings, quite a lot of buildings there.
Sorry, 108?
Yes, but that's somewhere else, is it?
I think, my lords, that may be somewhere else. My lord, this...
Give us a general idea.
It's just a general idea. My lords, the second point is this. The problem of dual registration was noticed by Mr. Lazarus, the respondent, in 1998, and he wrote to the Registrar of Lands asking for something to be done about it, but in fact nothing was done to rectify the problem, and you can see his letter at page 82.
Right.
Although I draw your attention to that simply to make the point that, in one sense, the whole problem in this case has arisen because the problem was noticed, but nothing was done to change the register, and so the purchaser
That's
comes...
ultimately a jury point. It doesn't affect the issue, does it?
No, my lord, but the jury point, my lord, it may be, but my lords... The third point is this. There's no allegation of fraud made by the respondent in the way that title was given to the appellant, or passed to the appellant. Like, can I just make this point as a general point, without going to the references? The evidence suggests, our evidence was to the effect that the respondent was not in occupation when the appellant, when we bought the land. And the references for that at page 15 and 30 of the record, that was our evidence.
Yes.
And there was also paragraph 10 of an affidavit at page 95 to the similar effect. And in answer to that, the respondent did accept that a large part of the disputed property, or part of the disputed property, was effectively overgrown. And you see that at paragraph 10 of his affidavit at page 162. The judge didn't make any findings on the issue because he didn't have to, because the 12 years of adverse possession had arisen earlier. Before we came on, it started in 1985-86. His findings are at page 220 to 221.
I mean, the assumption is that simply because it was registered on his title, therefore he was occupying the whole of it, even though most of it was overgrown and inaccessible, and all he built was 2 huts.
Yes, yes.
Well, I mean, that's a factual,
It's a factual point.
finding you're not challenging.
No, my lords, it goes to the disposal issue, because but what the point about disposal is if we're right, we say there's no allegation of fraud against us, so we say, and further, when you look at the findings and the evidence, there's no basis for an allegation of fraud were it to be made. That's why I make this point.
Now, on the other hand, you never ran this argument at first instance.
Well, I agree, but
no reason to consider whether there would be such an argument.
my lords, I accept that. But can I now go to the law?
But your main point is not how this gets disposed of, but what's the answer to the question of principle?
Yes. Okay. My lords, if I can go to the structure of the Acts, Bundle 1 of the authorities.
Yes.
The Limitation Act is at tab 1, the relevant provisions and familiar form. Page 610 is section 3. My lords, if I can just ask you to read that to yourselves, it's in standard form, the form that we found in England.
Both written cases, isn't it?
Yes, it's section 3 and section 30, my lords. Unless your lordships want to look at that again, section 3 is the standard provision preventing an action for recovery of land after 12 years, and section 30 on page 622 extinguishes title, and then goes to if I may, the original Registration of Titles Act at page 635, begins 635, and you can see in this the preamble. I go to this because the preamble is not repeated in the latest edition, but the preamble's at 642, and I submit, my lords, this is very important, the preamble. Whereas it is expedient to give certainty to the title to estates and land, and to facilitate the proof thereof, and, most importantly, also to render dealings with the land more simple and less expensive. And, my lords, I do submit that in the event of ambiguity, where on any footing there appears to be between section 68 and 70 in this case, this is something that really has to be given a lot of attention to, and I'll explain later why it doesn't seem to be featured at all in Chisholm and Home. My lords, going through this Act, going now to tab 3, which is the up-to-date version of the Act, beginning at 728. 737, section 2, all laws and practice relating to freehold and other interests, so far as inconsistent with the provisions of this Act, are hereby repealed, as far as regards their application to land on the provisions of this Act, and so on. And then, just in the definition section, page 738, you'll see the definition of proprietor, on 2/3 of the way down 738, and then also the definition of, I'll come to this later, transmission. Then sections 24 to 26, 747, this deals with the procedure for bringing land under the operation of the Acts, 24, 25 and 26. 26, my lords, I should draw your attention to. A person registered under this Act as proprietor of any land with absolute title shall be entitled to hold such land in fee simple, together with all rights, privileges, and so forth, subject as follows to the encumbrances, if any, on the certificate of title, and then B, to such liabilities and interests as may, under the provisions of this Act, subsist over land brought under the operation of this Act, without being entered on the certificate of title as encumbrances, but free from all other estates and so forth, save only 1 or 2 matters specifically referred to there. Section 20, my lords, that doesn't really take one very far, but it's the background to what you see later in section 70. Section 29, my lords, from this point on, the statute, for another 10 sections or so, the statute is dealing with first applications, and section 29 sets out the procedure for making a first application. I just draw that to your attention as part of the background as to when you make the application, there's quite a detailed procedure as to how you have to get your certificate as to how you have to persuade the registrar to register you with title. And then section 30, my lords, this is a provision I want to draw attention to in particular. A person applying to have any land brought under the operation of this Act shall describe and identify the land in one or other of the following ways, by plat or diagram or by metes and bounds. My lords, in other words, a provision which requires a detailed explanation as to what your land consists of, And my lords, unlike the Land Registration Act 1925 in England, which allowed for boundaries, which specifically said boundaries were not to be, as were, the plan was not to be taken as covering boundaries, here this, unless said otherwise, this seems to be providing for a detailed system of registration of precisely what it is you say your land is. And I do
So you're saying there's no general boundary rule?
There's no general boundary rule. And my lords, I do say that's important because the law of adverse possession does make some sense when you've got no general boundary rule, because it helps define, it can help define a boundary when the offence has been in place for a long time. It makes rather less sense when you've got a system which requires detailed measurements to identify on a register exactly what the land consists of. That's all, my lord. Section 55, page 7.
You've gone on from section 31. I think Mr. Wood places some reliance on section 31. So it's all got to go to the referee.
Yes.
And under section 31, he's got to be satisfied that the applicant is in possession by himself or a tenant.
Yes.
Yes, very well.
This all happened back in 78.
All this happened a long time, but back in 1978.
Yes, I mean, the concept of land being brought within the operation of the Act, which is obviously quite important.
Yes.
That all happened in 78.
Yes. I'm simply showing this by way of background. We don't need to concern ourselves in this case as to how the land was brought in. My lords, section...
No, but Mr. Wood says this impacts on the word subsequent that we're going to be reading shortly.
Yes, well, my lords, I shall be...
Very well.
Section 55 at 762... explains how land is brought under the operation of the Act.
Yeah.
The registrar registers a certificate certifying under his hand that a person therein named is the proprietor of the land, therein described or identified, either with absolute title or qualified title. And then section 60, page 764, provides that the registrar is not to enter notice of trusts. My lords, one then gets to the crucial provisions,
Yes.
which, if I may, I will come back to when I deal with the arguments. I just want to go to the what you might call the general provisions first. The crucial provisions, I think, can fairly be said to be 68 to 71.
Yes, you both set them out in full.
Yeah. And then section 83, my lords, I should just show you section 83. It's a point I'll be coming back to later. Every certificate, 774, every certificate...
Which section, sorry?
83.
Thank you.
Every certificate of any personal corporation being the proprietor of an estate in fee simple, whether in possession, remainder or reversion, and every instrument transferring or creating such an estate to or in favour of any personal corporation shall imply and be deemed to include the heirs of such person or the successors to such corporation. I'll explain the significance of that later. And then sections 85 to 87, my lords, these were introduced in 67, and they simply provide for a procedural mechanism, as we accept, for applying to the registrar rather than going to court if you want to get your rights as adverse possessor registered and noted with a certificate of title.
And despite Chisholm, they are merely expressed as may.
Yes. Section 88, my lords, is an important section referred to in Chisholm. I'll come back to that later, if I may. Section 91, my lords, the only point I want to get out of section 91 is this. This gives the registrar a power not to issue a certificate when there's a transfer, but if the transferee wants a new certificate, then he has to give him a new certificate. And you'll see that that's in the proviso, in the second paragraph of 91. Section 139 is the provision which allows for caveats to be entered on the register, and it's my submission that an adverse possessor most certainly can enter a caveat. I'll just refer to the relevant words, if I may. Page 808. Any beneficiary or other person claiming an estate or interest in land under the operation of this Act, and so forth, under any unregistered instruments, or by devolution in law, or otherwise, and it's the words or otherwise, may lodge a caveat with the registrar. And then there are provisions for how caveats...
Which section is that, sorry?
139.
Oh, 139, sorry.
And then the following sections deal with procedures relating to caveats.
Yes.
And then the other provisions, which I shall come back to later, but I just mention them now briefly in passing. First is section 153, which deals with registering, or rather rectifying the register, the power on the registrar to rectify a register. Section 158, which is another power in the registrar to rectify the register. I'll be coming back to that as well. And then section 161.
Well, no, it's a power in the judge.
Sorry, it's a power in the order, yes.
It's a registrar, really. It's not a power in the registrar.
Sorry, it's a power in the judge to direct the registrar.
Competent,
yes.
yes.
And my lords, obviously, I'll be coming to section 158 and that's 161 in due course. And then 161 is the next important section. And then finally 163. So that's the ambit, as it were, of the Act, which I will be referring to. Now, my lords, can I make my preliminary point, which is if the Court of Appeal's construction is correct, and indeed if Chisholm and Hall is correct, you have very odd consequences indeed. The first point is this, a general point. The adverse possessor can be wholly untraceable. He might have gone for a month or so, 2 weeks or whatever. He may be totally untraceable, but he could still come back and defeat title.
Yep.
So no matter how careful you are, as a bona fide purchaser, you're liable to be defeated by the adverse possessor.
Yes.
There's no requirement in this Act for the adverse possessor to be in possession at the time of the transfer. There's no sort of overriding interest type of provision.
I think you mean in occupation, don't you?
Occupation, yes.
Yes, but the normal position is, no doubt, that he would be there, and if he wasn't there physically in person, that there would be some trace of his possessory activities, either in the case of two huts or cultivation, fences or whatever. I mean, so, and the fact is that there are squatters, as far as one can see from the jurisprudence of this court, all over land in the Caribbean.
My lords, that is true. No doubt often it will be traceable, but often it will not be. Sometimes it will not be traceable. I'm just making a point on the proper construction of the Act. In my respectful submission, if it was seriously envisaged that you could lose to the adverse possessor, one would expect there to be some either express provision making that absolutely plain, or one would expect there to be something saying requiring the adverse possessor at least to be in actual occupation or discoverable at the time of the transfer to the purchaser. And there's neither of those two things. My lords, the second general point I make is this, that in a case where the bona fide purchaser loses to the adverse possessor, he won't get anything from the insurance fund. And my lords, that's because if you look at section 164 of the Act, volume 1, this prescribes the circumstances in which the adverse possessor is entitled. Page 823. This prescribes the circumstances in which you're entitled to compensation from the fund.
Yes.
My lords, if I can just ask you to read the first paragraph to yourself, and then I'll just make my point on it.
I mean, the point is simple. If the law is against you, then there's no mistake by the registrar,
Exactly.
which could give rise to such a claim. So you're left with a claim in damages against the seller.
Against the seller.
For failing to give a marketable title.
Who failed to give a marketable title, who by then may have disappeared. And the reason is because Section 164 requires you not to have any remedy against anyone, but Section 162 does give you a remedy against the vendor who has not passed title. So
whoever loses this appeal has a remedy against the vendor?
No, we have absolutely, if the vendor is good for the money, yes.
No, I'm not talking about good for the money.
Yes.
In principle,
yes.
Whoever loses this appeal has a remedy against the vendor.
Yes, I would have thought, my lords, that must be right.
And so really, Jamaica has had to ask itself, what should be our policy as to who should have a remedy against a vendor who may or may not be good for the money?
Yes.
It had to look at the policy questions
indeed.
arising out of that.
Yes, absolutely.
Yes.
I accept that. But anyway, my point for the moment is the assurance fund is not if we lose the adverse possessor, we get nothing from the assurance fund. Again, I submit that's surprising. You might have thought there might be some provision that would allow us to get something from the assurance fund in those circumstances. At least if it's undiscovered.
Against that, it could just be said, as effectively has been said to you, is that this allocation of risk It wasn't thought to be right that the insurance fund should be liable, but it was thought to be right that the purchaser should be able to recover from the seller.
Oh, yes, he should be able to recover. The problem, of course, maybe he will not be able to, and this is the big problem.
But this is allocation of risk, isn't it?
Yeah.
If you're wrong,
yes.
merely they decided not to extend this.
My lords, I don't say these are conclusive points, but I do submit they are points which should be borne in mind.
I see the
proper
force of your
construction.
point that you could have a case where there's innocent ignorance on the part of the vendor and innocent ignorance on the part of the purchaser. I see that.
But, my lords, the other oddity in my respectful submission, if we're wrong, is this: the bona fide purchaser loses to the squatter, however undiscoverable he may be. But when the squatter could easily have protected his interest. But on the other hand, the bona fide purchaser defeats the victim of fraud. And my lords, in my submission, that is very surprising. Supposing what happens is this: the vendor sells the property, first of all, or agrees to sell, first of all, to purchaser A. And purchaser A pays the money. And the vendor says, don't worry, I'll sort the registration out. But he doesn't. The vendor then agrees to sell the same property to B. B pays up. Now, in those circumstances, A has been defrauded of his money, but A has but the bona fide purchaser takes free of A's claim. The bona fide purchaser will defeat the claim of the prior supposed purchaser who's lost out.
All that means is that prima facie title operates according to paper, according to the registration.
Yes.
And obviously you couldn't have an exception in relation to private contractual dealings by the vendor, which is what you're postulating, uncompleted. But you could have an exception for normally visible facts on the ground. That's the argument against you.
Yeah.
Can I just put,
Yes.
Can I just put the second point? Going back to your insurance point, how could the registrar be made sensibly liable for failing to spot facts on the ground? The registrar isn't a land surveyor who trogs around the property and boots.
No,
So,
my lords,
there's no way you could have had the insurance.
that's exactly the point. My lord, that's exactly the point. You wouldn't have done it, but exactly. So if you've got a system without insurance, which couldn't seriously have insurance, is it really likely? And the whole system is to facilitate conveyancing.
But maybe vendors maybe purchasers are expected to go and know what they're buying and actually see it on the ground. That seems to be the lesson.
Well, my lord, that's
Your point is that sometimes it won't be obvious.
It won't be obvious, and the purchaser will be completely
I think we accept that is a possible criticism of the present system if you're wrong.
And my lords, I do submit it's important when you look at the purpose of this statute, which is to facilitate conveyancing.
Well, except that when we look at the sections you pass over, there are specific exceptions.
Exactly. And then one has to construe those sections.
Oh, one does, but all I'm saying is that it's clear there are those exceptions. For instance, easements. Yeah. You may well have a right-of-way which is completely unapparent, that isn't being used at the time. We all know how difficult it is to lose a right-of-way by non-use.
Yes.
And it may be that there's a right-of-way which considerably affects the value of the land, which is completely undiscoverable.
Yes. I accept that, my lord. I accept that. My lord, can I...
One small point, if I may, Mr. Knox. In 162,
Yes.
That is a claim, a statutory claim against the vendor or against the person who brought the land under the operation of the Act or who made an erroneous registration or acquired title to the estate or interest through fraud, error, or misdescription.
Yes.
It doesn't really cover the situation of adverse possession. There, I think one has to fall back on the common law obligation of marketable title.
Exactly.
Yes.
My lord, sorry, these are only what I call general considerations as to, in support of my construction, but I will now come to the specific points of construction, which are obviously much more important. My lords, can I just say what the three arguments are? To a certain extent, they're interrelated. The first is this. The Court of Appeal's construction ignores the indefeasibility provisions in section 161, which preclude any action being brought by the adverse possessor, in my submission, against a bona fide purchaser of value.
So if the bona fide purchaser of value goes into possession, takes up possession, 161 would prevent the adverse possessor claiming possession against him. Would that be true then if the person against whom the 12 years had been validly obtained went into possession? Why wouldn't that apply to such a case as well?
In my submission, If I may, I'll come to this.
Okay.
But the answer is simply Section 68 says you have the certificate as conclusive evidence that you are seized of the estate. So what you
Section
do...
68 says.
Section 68.
Section
70 doesn't, but Section 68, my lord. But my lord, can I deal with that point? In other words, what if the bona fide purchaser doesn't go into possession?
No. What happens if your owner of the paper
Yes.
title owner,
Yes.
I clock up 12 years
Yes.
occupation, you then go onto the land which I've acquired by adverse possession.
Yes.
If you're right on Section 161, how can I get possession back of that land?
You most certainly can. I'll come to that.
I see.
My lord, can I come to why the adverse possessor defeats as it were, the original owner? The adverse possessor also defeats the transferee not for value, but the adverse possessor does not defeat.
Yes, but despite Section 161.
But no, because of Section 161. I'll come to that if I may. So my first argument is 161 means the adverse possessor cannot
Yes,
defeat
understand
the
that.
bona fide purchaser.
Understand.
I'll explain in more detail.
Yeah,
when we get
fine,
to
fine.
that. The second point is this. Even if the indefeasibility provisions in Section 161 have no application to a claim by a squatter, his rights are at most those of a beneficiary under a trust before registration, which are overridden by a bona fide purchaser for value. I'll come, my lord, if I may, I'll come to the provisions.
Really the same point in different clothes, but yeah, okay.
Yeah. And my lords, the third point is this is a self-standing point. In any event, even if I'm wrong on the first 2 points, the rights of a bona fide purchaser for value prevail by virtue of Section 163 of the Act.
Yes, I see.
My lords, can I deal with the first argument, and that is the point about Section 161?
Yeah.
And for that purpose, we need to start at Section 68. Which is at page...
767, yep.
767.
Yep.
And my lords, the first part of this section
Yep.
appears to be dealing with the first registration. In other words, no certificate of title registered or granted under the Act shall be impeached or defeasible by reason or on account of any informality or irregularity in the application for the same, or in the proceedings previous to the registration of the certificate. My lords, I accept that bit appears to be talking about errors in procedure and so forth before land is brought under the Act. And then it continues, and importantly, my lords, and every, I emphasise the word every, certificate of title issued under any of the provisions herein contained shall be received in all courts as evidence, I just note that, as evidence of the particulars contained therein, set forth, and of the entry thereof in the register book, and shall, subject to the subsequent operation of any statute of limitations, be, and my lords, I emphasise this word, conclusive evidence that the person named in such certificate as the proprietor of, or having any estate or interest in, or power to appoint or dispose of the land there described, my lords, I emphasise these words, is seized or possessed of such estate or interest, or has such power. My lords, I emphasise the point, every person says everyone who's got a certificate of title. It's not applying just to the first certificate in relation to a piece of land. Secondly, in support of that, it's conclusive evidence that the person named in such certificate. And my lords, the way the system works is when, let's say I'm the purchaser and I buy the land off my learned friend, the same plot of land, what happens is I'm entitled to have a certificate issued in my name. You get that, I think, from Section 64. And you also get that, and you can also see, as it were, the importance of the name by going to, I think it's the third schedule, 833. What the certificate, in other words, is a certificate relating to you personally rather than to the land. Third schedule, 833, insert name in addition, is now the proprietor of an estate in fee simple and so forth. So I submit that what this is saying on its face, it couldn't be clearer on its face. When I get a certificate of title in my hands, I'm taken to be it's conclusive evidence that I'm seized or possessed of the estate.
Subject to the subsequent operation.
But that would mean, in my submission, on the face of it, I get it in my hands, but I can be defeated by someone acquiring title, in possession against me for 12 years. I can be defeated by a subsequent possessor, but not, by necessary implication, not by a prior possessor.
Can I just ask,
Yes.
did you say a moment ago that the first part of the section relates to the original bringing
Yes,
of the...
it does.
Bringing of the
Yes.
land within
Yes.
the... Well, if that's right, then it's not very elegant, but subject to the subsequent operation is capable of meaning subsequent to the original bringing into the scheme of the Act of this land by original registration.
My lords, I accept you could. I mean, and part of the problem is these two sections, sections 68 and 70 on their own, are not well drafted.
But that's the point which Lord Jenkins makes in Chisholm.
Yes, I accept that. But, my lords, he does also accept on its face this provision would be helpful. I mean, in other words, if you left section 70 out, I respectfully submit the natural construction of section 68, just taken on its own, is that it applies to every certificate of title, and once my name's on that certificate, I'm entitled to the land. My lords, there are few... Sorry.
If you're relying on the semicolon at the,
Yes.
at the top of page 768.
Yes. I rely on the word semicolon, the word every, and the word named.
But does it become quite important or interesting at this point to ask whether you're right in insisting that we're not interested in whether there's notice or not? Because it's a rather strange concept that someone, a bona fide... I mean, what does bona fides mean if it doesn't involve lack of notice?
Well, the whole structure of the Act is this. Mere notice is not to be taken as evidence of fraud. I will come to this.
So you can happily buy property on which there is a long-established squatter, and you can say to yourself, he hasn't troubled to have his title registered, and I can override it.
Well,
and then next day, having bought it, without him knowing, I can boot him out.
Well, my lord, that's the whole point of this, the whole scheme of the Act. I might well know, for instance, of a previous purchaser.
That's the whole point. If you're right, I mean, the whole point of the torrent system and of registered title is that that's precisely what happens, unless there's an exception, as there is under our land registration, for people in occupation. And your point is there's no such exception in relation to this Act. So if you're right, it simply means you register, or if you don't register, hard luck.
Yes. And my lords, that's been held in relation not just to adverse possessors, it's the whole point of the system.
I understand the point, but it does suggest that there are merit points to be made on both sides.
Well, may I make my submissions and come back?
Certainly one can go this far, that throughout the Act, in particular the sections you've passed over and going to come back to, but also section 68, that clearly the draftsman is continually seeing adverse possession as a special case. Because all the other cases he talks about are temporary rights or rights over the land. They're not actually taking away title. But adverse possession is constantly seen as an exception, together with, for instance, easements, together with 3-year tenancies. But it's exceptional because it actually takes away the title, whereas the others
they don't. But my lord, it's only section 68 and 70 which talk about adverse possession.
Well, there are other sections that do by cross-reference back.
My lord, can I just, while I'm still on section 68, can I just make this point, and it's an important point, very important point. Section 68 is not subject to any fraud exception. It's a point I'll return to later. Why not? And, my lords, I will be submitting in due course that it is plainly presupposing, it is the premise of section 68, is that it is presupposing that a certificate of title has been issued pursuant to a purchase, pursuant to a sale to a bona fide purchaser for value, not to a voluntary transfer.
If it means, if every certificate of title are the words after the semicolon that Lord Hodges referred to, if that refers literally to every certificate of title, it would also presumably start time running again if you lost your certificate and got a fresh one.
No, because I have to be bona fide purchaser of value. What it is presupposing is
Well,
that
where do you get that from section 68?
Well, my lords, if I may, I should come back to, if I may, I mean, my submission is, and I will, if I may develop this when I've gone to section 161, the premise of section 68 is that there has been a bona fide purchasers for value.
Well, the other option is that it is, as Lord Mance says, referring to the first certificate.
Yes. My lord, that's
Those are the two options, aren't they?
Yes.
Doesn't it make better sense to imply that the certificate referred to after the semicolon is similar to the certificate referred to at the beginning and what it's really concerned with, rather than implying the bona fide purchase of value would be very easy to refer to if one was intending to refer to him or her.
Well, my lords, I will be submitting it is intended
Yep.
to apply to a bona fide purchaser of a value. It is not intended to apply to mere transferees. If I may develop this submission
Okay.
later, that's why we see no exception to fraud. My lord, the other point I want to make on section 70 is this. If, in fact, the holder of...
Not a bona fide purchase of value without notice, merely a bona fide purchase of a value.
Yes.
Okay.
If in fact, section 68 really is subject to prior adverse rights, then the last bit of it is absolutely meaningless. That is to say, the bit that says you are taking conclusive evidence. What you're supposed to be able to do in my submission is hold up the certificate of title in court and say, look, this is conclusive evidence that I'm seized or possessed of this estate. In other words, you might say you're in possession, but this is conclusive evidence that I'm in possession. Now, if you in fact read section 68 as subject to prior adverse rights, what's the point of the seized or possessed of such estate provision? It becomes utterly meaningless. So I submit that the premise of this is it is saying you are taken to be seized by virtue of the fact you've got the certificate of title in your hands of the estate. And that will defeat the claim of an adverse possessor, unless, of course, he's someone who acquires the rights against you by virtue of the subsequent operation of the act.
But if the whole section refers to original certificates, that point goes, does it?
Yes, it does. If it refers to original certificates.
It can't, I mean, it's got to be referring to the current certificate, because if you're concerned with the person named in the current certificate. So the second part is obviously concerned with the current certificate.
But I would, exactly, my lord.
Obviously, you're coming on to the proviso to section 70
yes.
shortly, but you will know that within that there's a considerable problem for you in the interpretation you're just advancing about what subsequent means.
Well, in my submission, not, but I will, if I may, I will.
Very well.
But I do respectfully submit section 68 looked at naturally, and this indeed was the approach of the Privy Council in Chisholm Hall, looked at naturally. Section 68 is talking about every succeeding certificate of title, not just to the first. And if it was just referring to the first, it wouldn't, in my submission, be drafted in the terms it is. And then, my lords, goes to section 70. And my lords, just turning to the main part of that section, page 768.
Yes.
You'll note one point which doesn't apply to section 68. It is applying to the case, it makes an express exception for fraud. That's 6 lines down. The proprietor of the land or estate or interest of the land under the operation of the Act shall, except in the case of fraud, hold the same as may be described, and so on. And then there are various other exceptions given in the main part of the section. And you'll note the last part of the main part of the section is making an exception. Perhaps I can take it from 5 lines from the end. And except as regards any portion of land that may, by wrong description of parcels or boundaries, be included in the certificate of title instrument evidencing the title of such proprietor, not being a purchase of a valuable consideration or deriving from or through such a purchaser. Now, in my respectful submission, section 70 is not presupposing a bona fide purchase of a value. Hence, you've got the express provision for except for fraud, and you've then got this part at the end, which is referring to the position of the bona fide purchase of a value as not coming in with the main part, at least in that respect, of section 70. You then have the proviso, my lords.
Wait a minute, you say it doesn't refer to a purchase of valuable consideration.
Well, it does refer, yes, my lords. I accept it is referring to that, but my lords, my point about the first part of section 70 is that it is not premised on the position of a bona fide purchase of a value. Unlike section 68, which in my submission is premised on the position of a bona fide purchase of a value.
But the very fact that in section 70 the draftsman has thought it right to refer and deal with a purchase of a valuable consideration makes it difficult to say that such a person is to be implied in a section that last but one section ahead of it, isn't it?
My lords, in my submission, not. My lords, if I may, because in my submission the real problem with if I may say, this statute and Chisholm Hall, is it doesn't look at all the other provisions in the Act. And I submit if you do look at all the other provisions in the Act, it gives a much better idea as to how to interpret Section 68 and 70 taken together. So, my Lords, I'm just making what you might call prima facie submissions. I will develop them by reference to the other provisions in the Act in a moment. My Lords, we then have the proviso, and I accept it on the face of the proviso. That appears to be saying, well, if you've got a certificate of title, that is subject to the operation of the Limitation Act since the first certificate was issued.
Yes.
And, my Lords, I accept on a prima facie reading that is right.
Well, yes, it is.
I mean, I can't get round that. No. But, my Lords, what I do say is you've got on the face of it two inconsistent provisions. Section 68, certainly I submit, read naturally, says once you've got a title, it's only subsequent acts. Section 70 has a savings provision, which seems to suppose that you're liable to be defeated by a prior act.
Well, Lord Jenkins' explanation was that subsequent in Section 68 means subsequent to the issue of the certificate,
yes.
personal certificate.
Yes.
How, if you read Section 68, as you say literally, how do you, as it were, construe the plain words, as I see it, of the proviso in Section 70? Well,
my Lords, if I may, I shall come back to that. In my submission, they are not intended to expand the specific limitation which you see in Section 68. In other words, in Section 68, the certificate holder's rights are subject only to subsequent adverse possession. That's the natural reading in my submission of Section 68. Section 70 seems to say, no, your rights are subject to prior.
But how do you actually read it as a matter of language, other than saying it must be limited? Because in this case, as a matter of ordinary language, it has to be said, and I'm sure you'd accept, that Mr. Lazarus did acquire
yes.
a right over such land under the operation of the statute of limitations.
Well, my Lord...
How do you actually read those words? To give effect to what...
my Lord, in my submission, one has to go outside these provisions to see what the rest of the statute provides. If you do that, in my submission, you come up with one of two constructions, but I submit it doesn't matter which. The first is this: Section 68 trumps Section 70. You should read Section 70 as merely a savings provision, which is not intended to expand Section 68.
That's saying that inconsistency in Section 68 prevails.
Yes.
The second option?
The second one is to say Section 70 on its face prevails, but that is still subject to Section 161. And that is to say, your title, the title of the bona fide purchase of the value, is simply indefeasible by anyone, save in the circumstances set out in Section 161. And therefore, really, the dispute, if I can put it that way, between Section 68 and Section 70 is in the end immaterial.
Yes, I see. That's very helpful. Thank you.
And, my Lords, that's why I want to get
That's very clear. Thank you.
to Section 161.
But what is clear under the proviso is that you can, in any certificate, in other words, it could be the fifth certificate by the fifth purchaser or fourth purchaser, any certificate may be subject to factually acquired rights of others, such as the public rights of way, or easements, private rights, and so on, which may not have been used or be apparent. And along with those is lumped rights acquired under the statute of limitations.
Yes. My Lords, it's my submission that when you look at Section 161, I really want to get there, that the most you can look at in the most you get out of the proviso is this: the original owner, if I can put it that way, against whom the 12 years run, he is bound. But also a transferee, not for that, a transmittee, let's say an heir or whatever, he is bound. Also a transferee not for value, he's also bound. I accept all that as a result of Section 70. What I say is Section 161, there's a special protection given for bona fide purchases of value which overrides Section 70 on any footing.
Can you help me on this then? The proviso also refers to a tenant for a term of less than 3 years. How do you say that works? Does, if I grant a tenancy of less than 3 years, sell to you, and you then go in and kick out the tenant, is he stymied by Section 161 as well?
My Lords, I don't think he is. No, I'm going
Because?
to come to, because one needs to look at Section 161 itself.
Okay.
My Lords, in other words, Section 161 saves the bona fide purchase of the value against, in relation to his title, but not necessarily against the 3-year lessee. One needs
Section
to come.
161 talks about possession, doesn't it? Anyway, let's have
recovery
a look at 161, yeah.
My Lords, can I go to Section 161?
Of course you can, yeah.
Section 161, page 821. No action of ejectment or other action, suit or proceeding for the recovery of land, of any land, shall lie or be sustained against the person registered as proprietor thereof, under the provisions of this Act, except in any of the following cases, that is to say. Now, A is immaterial, B is immaterial, C is immaterial, D is the case of fraud, that too is immaterial, and E, I come to E. In my submission, this is the crucial provision. The case of a person deprived of claiming any land included in any certificate of title of other land by misdescription of such other land or of its boundaries as against the registered proprietor of such other land, not being a transferee thereof for value. Now, my Lords, what I submit is what I submit happens is this. The reason I say this is so important is this. Let's say, take this case, adverse possessor was in possession for over 12 years against my predecessor, Mr. McGann. From that point, once the 12 years were up, Mr. McGann's certificate of title contained the wrong parcels within it, because it contained within it the disputed strip of land, when in fact Mr. McGann's title to the disputed strip of land had been extinguished by virtue of Section 30 of the Limitation Acts. So from that moment on, Mr. McGann's title contained a misdescription within it. Now, my Lords, misdescription has to be read in my submission with what you see back in Section 70, because it's quite plain Section 161 is dealing with the same concepts as Section 70. It is talking about, misdescription is talking about, the passage I referred to earlier is talking about wrong description of parcels or boundaries. So what, in my submission, happens as soon as Mr. McGann, as soon as the 12 years are up, is the certificate of title is misleading. It's got the wrong parcels in it, or wrong boundaries within it. From that moment on, my Lords, from that moment on, Mr. Lazarus could bring a claim for the recovery of land against Mr. McGann under Section 161E, because he would say, look, your certificate is now misleading because I own the disputed strip. Now, I want you to get out. And he'd be entitled to say that against Mr. McGann as the registered proprietor and as against anyone who is not a transferee bona fide for value. But so in other words, let's say Mr. McGann had transferred the land to his son for no consideration. In my submission, again, Mr. Lazarus could bring a claim. Mr. Lazarus could bring a claim against the son, mere transferee, not for value. But once the land is transferred to the bona fide purchaser of value, the fact there's a misdescription in the certificate, or it contains the wrong parcels, is immaterial. The bona fide purchaser of value can simply say, I'm very sorry, you cannot bring an action against me for the recovery of land. And that, in my submission, is the effect of Section 161E. And that's why I say...
I find, speaking entirely for myself, I find the wording of paragraph E very difficult.
Well,
the case of a person, so we're talking about really the claim of a person. So you were hypothesizing this is Mr. Lazarus.
Yes.
And he's deprived of land included in any certificate of title of other land.
Yes, which is ours, which is Mr. McGann's. Let's say Mr. McGann's land for present purposes.
But it's a land other than the land he wants to recover.
No.
Up at the top, isn't it? My other land. The top is no action of ejectment for the recovery of any land shall lie.
Yes.
And then here we've got at E, somebody claiming that he's been deprived of land included in a certificate of title of other land, Mr.
Well, my lords, if I can just come for a moment, leave on one side the grammar, which I agree, it is badly written. But in my submission, the sense of it is plain. What this is allowing me to do is to say, look, in your certificate of title, there is something which ought to be in my certificate of title. There's a plot of land noted in your certificate which ought to be in my certificate. Therefore, I'm going to get you out. I can bring an action for recovery of land against you, because that plot of land should not be in your certificate, it should be in my certificate. That's what it's talking about.
Yes, but it's hardly addressing this sort of situation. It's addressing a situation where there's a muddle in the description of two adjacent plots, not where one plot is being carved out of another plot by adverse possession.
In my submission, no.
Well, you say it's wide enough to cover
it. Most certainly is.
But then it only applies in the very odd situation where the adverse possessor is, for some reason, having to try to recover possession of the land again, presumably because he's lost his adverse possession.
No, not because he's lost his adverse possession rights.
But he's lost possession.
He's not in occupation.
Not in occupation.
My lord, if I may respectfully say, the draftsman would have known that 99 cases out of 100, where a purchaser comes in or where the paper owner comes in, there's always a dispute between the paper owner saying the land is mine, get out, and the adverse possessor putting in a counterclaim saying, no, it's mine, you get out. I mean,
is he really dealing with adverse possession at all? You say he is, but the primary thing he's dealing with is something completely different, isn't it?
In my submission, he has to be, because otherwise the adverse possessor has no rights whatsoever to recover land. That's what it comes down to.
Is this really a misdescription? Because if you look at section 70 and the proviso, if it means what's said against it and what Lord Jenkins says it's missing, it's not a misdescription. He still holds that land, but he holds it subject to the rights of the adverse possessor.
No, in my submission it becomes, the misdescription has to be read together with the main part of section 70, which talks about wrong parcels of land. Well, it's obviously a reference back in my submission to that, because the concepts in D, E and F in 161 are all concepts you see in the main part of section 70.
But if one were to read the proviso in section 70 as deeming the certificate to contain the encumbrance, and that is a reading which is open in the proviso, then there is no misdescription.
Well, my lords, the difficulty is this. In my submission, the section 161 is setting out those circumstances in which a person who wants to recover land can do so. The question is, there are no other circumstances, my lord, in which you can recover land against the registered proprietor. Section 161 is an exclusive code, and I will come to the authorities on that.
But that won't help the three-year tenant, will it? How does a three-year tenant deal with a purchaser landlord taking possession of his land and him wanting to get it back?
Well,
which paragraph of section 161 does he read?
Well, in other words, how could the tenant, the three-year tenant...
The three-year tenant who's evicted, possibly innocently because he's on holiday and the purchaser doesn't realise. Which paragraph does he rely on for an action of ejectment, suit or proceedings for the recovery of the land let to him?
Well, my lords, I think the answer might simply be that this is not dealing with actions for recovery of land by a tenant.
Well, why not? There's no action of ejectment or other actions, suit or proceedings for the recovery of any land.
Yes. My lords, if I can come back to the point, what I have a moment to think about it, but in my respectful submission, the important point here is how does the adverse possessor, if section 161 means what it appears to say, how does the adverse possessor get his land back?
But 161, according to Pottinger, is designed to maintain the faith of the register.
Yes.
So that which is on the register can be enforced and subject to certain exceptions. If Section 70 has the effect that the rights of the adverse possessor or the tenant for under a term of not exceeding 3 years is deemed to be on the register, then 161 doesn't bite at all.
Well, My lords, that might be the case. You're talking about the 3-year tenant, my lord.
Or the adverse possessor.
But, my lords, in my submission, the problem is one has to start with the fact that there appears to be at least a conflict between Section 68 and Section 70.
Yes, but absolutely. But if Section 70 is construed against you,
yes,
is Section 161 a bar?
Well, in my submission, it would be, because even with let's say Section 70. Let's say there is an adverse right which has been acquired against me before I bought the land. In my respectful submission, my certificate of title, or the vendor's certificate of title, is misleading, and so is my certificate of title misleading. My lords, I respectfully submit that is, on any footing, a perfectly proper construction. The certificate automatically becomes misleading because it contains the wrong parcels within it once the adverse rights have been acquired. And that, in my lords, it makes perfect sense in my respectful submission to say in Section 161 of the adverse possessor, well, you can bring your claim within Section 161E, but against everyone except the bona fide purchaser of value. My lords, I accept, of course, there are difficulties in the construction of this Act, but, my lords, if I'm wrong, what are the rights of the adverse possessor to bring any action for the recovery of land? There appear to be none.
Well, first of all, he gets himself onto the register. Doesn't he use the new procedure?
No, my lords, in my submission, not. The new procedure is merely procedural. It wasn't intended to alter the substantive law. And that's common ground. There's no doubt about that.
Under Section 85, he can apply to be registered as the proprietor, and then, if you've got that to hand,
yes,
under subsection 2 of 86, earlier provisions kick in,
yes,
including in particular Section 44, which means that when there's an application, the registrar notifies, and then there can be a summons before the judge and all that, and the
yes,
judge sorts it out.
Yes.
And so, as a result of the judge sorting it out, there will then be a rectification of the register, and Section 161 won't apply.
No, in my submission, I understand what your lordship is saying, but with respect, it's not accurate. The effect of Pottinger and Raffoli is that your title is indefeasible. Section 161 is effectively, and I might add also another Privy Council decision, Fraser and Walker. The effect of Section 161 is to confer indefeasibility of title. You cannot jump out of the hoops of Section 161 by referring to procedural provisions which don't contain the same restrictions as Section 161. So, in other words, Section 85 in my submission, and it was held by the court below to be no more than a procedural provision, which did not alter the substantive law. So if I'm right in saying the substantive law before Section 85 was you had to come within Section 161 before you could get yourself onto the register, then in my submission, Section 85 has made no difference to that.
At the moment, I don't follow that, because Section 161 is talking about actions against the person registered as proprietor. And if the adverse possessor can get himself registered as proprietor under a procedural section instead of the earlier proprietor, then there's no Section 161 problem.
Well, my lord, if I may come to the authorities on this,
yes,
I do submit Section.
I see how you say it.
It really is. It's so fundamental that Section 161 has always been referred to as what you might call the indefeasibility provision throughout all the Commonwealth.
That's all very fine and dandy. One sees that, but why isn't it perfectly simple? That I think effectively what Lord Hodge put to you, that is all subject to the proviso in Section 70. Those rights are, as it were, deemed to be included on the title, and the easements, rates, taxes, and so on, quit rents, 3-year tenancies, and rights obtained under limitation legislation.
Well, my lords,
and as I say, at the moment, I have some difficulty with, if you're right, seeing how the 3-year tenant is protected, but we're going to come back to that.
My lords, perhaps I can come back to that. My lords, can I just summarise my two answers to that? First of all, I submit I'm going to Section 161 precisely in order to resolve the conflict between Section 68 and Section 70. So when one goes to Section 161, one shouldn't start on the presumption that Section 70 trumps Section 68. One starts with the presumption you've got a conflict.
Well, wait a minute, what about Section 88?
So Section
88, which I think deals with the registration of a transfer. saying
Yes.
the transferee takes, as it were, subject to all the rights of the transferor.
My lords, I was going to come to that in due course.
Fine, okay.
May I come to that when I'm dealing
Yes, if you
with
want
Chisholm?
to.
But in my submission, that has nothing to do with it, with great respect. My lords, I do respectfully submit that the proper analysis is this. Section 68 and Section 70 appear to be in conflict. To resolve the conflict, you go to the rest of the statute, and not just Section 161. I'll come to other provisions too. Section 161 presupposes, in my respectful submission, that once a certificate, once adverse rights have been obtained, the certificate is misleading, and if the adverse possessor wants to recover land, he then brings it within Section 161E. But
Now,
nothing else.
may I suggest that on that point, actually, rather than supporting you as you're submitting, Section 70 undermines the point, because the cross-reference between Section 161E, misdescription,
Yes.
and Section 70 is to the first paragraph of Section 70, wrong description,
Yes.
right? And therefore, on your analysis, the proviso reference in the second part of Section 70 to statute of limitations is completely unnecessary, because limitations have already been covered under the head of wrong description.
Well, no.
On the contrary, the proviso, the point I'm putting you,
Yes.
is essential, because limitation problems are not covered under misdescription or wrong description. I mean, that's demonstrated by the need for the proviso at all.
My lord, that, if I may say, reads too much into the first part of the proviso. In my respectful submission, you look at 161...
No, it doesn't. It reads the words wrong description and
Yes.
misdescription as similar as you're inviting us
Yes.
to do, and it therefore points out that it follows that the limitation can't be a matter of misdescription or wrong description. Limitation requires separate reference, which you find in the proviso.
But, my lords, I understand your lordship's point, but then one gets back to this point. How can the adverse possessor recover land? Supposing, as happened in this case...
Well, I mean, that, you'll get back to the point about the 3-year tenant and so on. But there's the same problem. And there isn't any provision in this Act relating to enforcement of rights of way, or is there, perhaps that doesn't matter because you're not recovering possession.
But, my lord, no action of ejectment or other action shall lie against the person registered as proprietor. Yeah. My lords, one can't get round those words. We are registered as proprietor. It might be said, well, look, in the action that's been brought against us, how come? We've got a certificate of title. And my lords, it's not, in my submission, easy to see how. You say,
You're dealing with a relatively rare situation where the adverse possessor, having established his title or her title, has lost possession, aren't you? And maybe it isn't expressly covered.
Well, my lord, not exactly lost possession, but a fight takes place. I mean, my lords, in my submission, it's very common that there is a dispute between the paper title owner and the adverse possessor. And, my lords, one might think, especially when a bona fide purchaser comes along, he's almost certainly going to want to assert his rights of possession. So in my submission, you can't say, well, Section 161 is all on the premise. It can't apply to adverse possessors because they're already in possession. Often they won't be, or there'll be a fight about it. My lords, can I just go to the case of Pottinger? Because in my submission it is important. It's in Volume 3 of the Authorities. At tab 34. Begins at page 1620. And one can pick it up at paragraph 18 on 1626. And this was a case where Mr. Pottinger had actually acquired a possessory title, and Miss Raffoli said he had fraudulently obtained that possessory title because she wanted to have that same plot of land herself. And what happened is, in the Court of Appeal, the Court of Appeal held, well, Mr. Pottinger hadn't acted fraudulently, but it acted wrongfully, and therefore it exercised its power to rectify the register, or a purported power to rectify the register under Section 153. And you see that from paragraph 18. And the Privy Council held, well, that's not right. There's no general power of rectification given by Section 153. And that's really what this case comes down to. And at paragraph 20, page 1627, you'll see what the board there says about the main aim of this system of registration is to ensure that proprietor's title is secure and indefeasible except in certain limited circumstances identified in the legislation. This is achieved by section 161. And then he sets that out. Then over the page, 1628, Lord Roger summarises the basic rule, which is set out in effect at the end of section 161. Paragraph 21, if the claimant succeeded in her action under section 161 and recovered land, then section 158 would furnish the court with the necessary powers to give her victory. And my lords, I accept. And I say here, the same would apply to the adverse possessor. The adverse possessor could ask the court, having won under 161, would ask the court to exercise its powers under 158. And then paragraph 22, the board makes the point that the Court of Appeal led the claimant to victory, as Lord Roger puts it, by an entirely different route. He held that Miss Raffoni could not succeed under section 161 because she couldn't prove fraud, but he treated section 153 as permitting the court to cancel Mr. Pottinger's certificates of title to the lots on the ground they'd been, quote, wrongfully obtained. And section 20, para 23, section 153 is not concerned with the fundamental matter of the validity of title of a proprietor whose name appears on the register. Rather, it provides the registrar with what are essentially administrative powers to deal with significant but less fundamental problems relating to certificates which evidence that title. The duplicate certificate of title which the proprietor receives from the registrar is a most important document, since subject to the exceptions in 161, it is incontrovertible proof of his title to the land in question. It should be accurate and so forth, and then a description is given of the certificate. And then paragraph 25, therefore, when section 153 refers to a certificate of title being fraudulently or wrongfully obtained, it is referring quite specifically to the certificate rather than to the title, and so forth. And then over the page, paragraph 26, first and most importantly, these are reasons why the Court of Appeal's decision was held to be wrong. The broader interpretation favoured by Smith J.A. would be wholly inconsistent with the overall approach of the statute. In the words of Lord Oliver and Honeyball, registration confers, quote, an unassailable title on the proprietor, shown in the certificate of title, save in the specific cases enumerated in section 161. Paragraph D speaks of a person that goes on to say what that is. The same policy of confining the attack on title to cases of fraud is reflected in section 1771, a statute which contained a parallel provision allowing title to be attacked on the ground it had been fraudulently or wrongfully obtained would be utterly incoherent. And then further reasons are given for saying section 153 is merely a procedural provision which doesn't affect the indefeasibility provisions in section 161. And my lords, in my respectful submission, exactly the same line of reasoning applies. In this case, assume I'm right for the moment in saying the loss of my title to a particular plot of land means that my title now includes the wrong parcels within it, so as to bring the case within section 161E. I submit exactly the same principle applies. The adverse possessor either gets through section 161E on the basis he's bringing a claim against the original owner or against the transferee not for value, but if in fact he's claiming his rights against the transferee for value, then he's knocked back by section 161E. And he cannot, as it were, circumvent that by saying, oh, well, never mind about that. I can get my title registered under section 153. Obviously not. And I say, likewise, he cannot circumvent that by using the new procedure, and it is a new procedure, set out in section 85, because that, again, is intended only to effect a procedural reform, not a substantive reform. So, my lords, I do submit the question for you is whether section 161, as I say, is intended to apply to the case of an adverse possessor, in particular section 161E.
Is there anything inconsistent between this and the suggestion that the adverse possession contemplated by section 70, the proviso to section 70, is treated as it were, overriding the registered title?
In my submission, there is, because...
So you say this decision is inconsistent with the earlier decision of the Privy Council?
Well, I say, my lords, it hasn't been, when I talk about Chisholm and Home,
Yes.
in my respectful submission, Chisholm and Home simply doesn't consider Section 100.
No, that's not what I'm saying. You're saying this decision is inconsistent with the reasoning on this issue in Chisholm, is it?
Well, my lords, I don't think I can go as far as to say it's inconsistent.
Quite.
I think all I can say is Chisholm and Home simply doesn't consider the impact of Section 161 in resolving the conflict between Section 68 and Section 70.
And this case doesn't consider the effect of the proviso to Section 70.
No, it doesn't.
Section 70 is only referred to as in a throwaway line in paragraph 26. Yeah.
Yes. My lords, I accept that. But, my lords, I come back to my basic point.
Yeah.
What is Section 161 doing? If I'm right, then I submit that I must win this case. If I'm wrong, and Section 161 has no application to the claim by the adverse possessor, I say, well, how does the adverse possessor ever recover land once he's lost it? There's no other provision in the Act for him to do so. And Section 161 appears to say, no action and ejectment shall be brought against the person holding the certificate of title. Now, my lords,
This wasn't an action by someone who was claiming as an adverse possessor. This was an action against someone who had got his title registered as an adverse.
Yes, oh, indeed, yes.
And so this is a straightforward action within 161, where someone is saying, I'm a bona fide purchaser. And
yes.
Trying to, it's a completely different kettle.
It's a different action, but the principle is the same. The principle is you've got to show that Section 161 is the indefeasibility of title provision.
What this case does is to emphasise you're right that Section 161 is very important. It underlines the importance of registration.
Yes.
And the value of registration, and it's consistent with Section 68, and you say in particular your interpretation of Section 68.
And it limits the rights. It limits your rights to rectification of the register. My lords, what the adverse possessor needs is rectification of the register. And in my respectful submission, how does he get to rectify the register?
Does he need Does he need that in light of the proviso?
In my submission, yes. But my lords, of course, my lord, if you start from the position the proviso is the dominating provision, maybe not. I mean, maybe not. But in my submission, you shouldn't start from that position. You start from the position there's a conflict. You then look elsewhere in the statute to resolve that conflict. Section 161, in my submission, read naturally, seems to be saying that the adverse possessor cannot bring a claim under Section 161E against everyone except the bona fide purchaser of value. Therefore, he cannot bring himself within Section 161E against the purchaser of value. Therefore, he cannot, as it were, get round that by saying, well, I'll register my rights under some other section.
Understand.
And my lord, that really is the nature of my argument. It all turns on, and I say that the force of my argument is this. If I'm wrong, A, how does the adverse possessor ever bring a claim for damages and ejectment, bearing in mind the words of Section 161? He can't. I can simply put my certificate of title up. Those are the words of Section 161. Secondly, how can he get himself onto the register? And my submission, the notion that, as it were, the intention of the Act is the adverse possessor doesn't have to get himself onto the register is, in my submission, wrong. My lords, can I go to Section... it's Volume 1. If I can go to, I think it's Section 157 from recollection, or maybe 158. So in my submission, this sets out how the scheme works. I've dealt with 161. Take 158. Because page 819.
119?
819. 819. Upon the recovery of any land, estate, or interest by any proceeding at law or equity from the person registered as proprietor thereof, it shall be lawful for the court or judge to direct the registrar. Now, in my submission, this is setting out how you get yourself onto the register and get yourself a certificate of title as the adverse possessor. And in my respectful submission, one must construe the Act as intending that the adverse possessor has to get a title for himself.
Mr. Knox, I've already asked you about Section 85. You've dismissed that on the basis it's entirely procedural. But I'm sorry, you've only got to read Section 85 to see what the adverse possessor does.
Yes.
He's not on the title, he can apply to be registered. And when he's registered, the bar in section 161 does not operate.
In my respectful submission, that would be inconsistent with Pottinger and Rathone, because Section 85 is merely a procedural provision.
Of course it is. You're saying, how does the adverse possessor do it? You're asking a procedural question. I'm suggesting to you a procedural answer.
My lords, forgive me. When I say how does he do it, I mean this. How, bearing in mind the indefeasibility provisions of Section 161, does he do it? In my respect, the way the statute works is the rights of the certificate holder are indefeasible. They can be defeated by an action under Section 161. Once you've as well won under Section 161E, you then, this is what you do at law. You would then get the judge to order under Section 158 rectification of the register. That, my lord, is what you might call the old system. That's what an adverse possessor used to have to do. But he would have to. He couldn't ask the court to. He couldn't ask the court.
I think your short answer is a slightly different one. It is that a person who can claim he has acquired title by possession to land does not apply to somebody who has got 12 years only against the predecessor of the registered proprietor.
Yes.
That's got to be your answer.
Yes, that's right.
Hasn't it? Otherwise, you are down the slippery slope. Your whole point is he hasn't acquired a title which is valid against the current registered proprietor.
And my lords, if I can just for the moment summarise what I said, the position was before Section 85 came in. Before Section 85 comes in, the adverse possessor, in my submission, brings an action under Section 161. He wins, and then he gets an order under Section 158.
It looks as 158 came in 1967, but there was an equivalent before.
There was an equivalent before, my lords, which you can see at page 697 in the original Act. So Section 158 is simply playing with the words rather than introducing a new concept.
Thank you.
So in my submission, that's how it used to work. If I can deal with my Lord Wilson's point about Section 85. The scheme of the Act was adverse possessor brings claim under Section 161, if he can. If he wins, he then gets an order for rectification of the register under Section 158. He cannot do anything under Section 153. That's Pottinger and Rathone. Query, what's the effect of Section 85 when that comes in? Does that alter what you might call the substantive law relating to indefeasibility of title? I say no. It provides a new procedure. In other words, he doesn't have to go to court anymore. He can simply apply to the registrar. But on that application to the registrar, all the same defences can be run by the paper title owner as could have been run at law in the courts. That, in my submission, is how the scheme of the Act works. Forgive me for not having made myself clear before, but that, in my submission, is the answer to the Section 85 point. It is introducing a new procedure, but it doesn't, by doing so, allow the adverse possessor to escape the clutches, if I can call it that, of Section 161. He's still got to get within Section 161.
Sorry, just to go back, I missed it. Which was the equivalent of Section 158 in the old?
Forgive me, my lord. It was, I've got a note of it, 697, perhaps it's the wrong, it would have been 124, right at the foot of 697.
Well, that's error or misdescription. I'm looking for something equivalent to the power of the court.
That may be the wrong reference, actually. I think it's 130, page 700, forgive me, page 700. Upon the recovery, Section 130 of the old Act.
I see. Yes, the new one seems to be a bit wider since it deals with corrections.
Yes. But essentially it's the same procedure is envisaged, but rather greater remedies are on offer.
Thank you.
My Lords, can I just ask you briefly to look at Fraser and Walker, which is another Privy Council decision, I think from New Zealand, on materially identical provisions, so far as concern my argument. And you can find that in the Authorities Bundle at tab 26, page 1489.
Page, sorry?
14, it begins at 1489.
Thank you.
My Lords, just very briefly, if I can summarise what happened in this case. The appellant's wife forged his signature on a transfer. As a result, land was transferred to a purchaser, who was the first respondent, who in turn mortgaged it to the second respondent. And those transactions were registered. The appellant then tried to set aside both the transfer and the mortgage on the basis that there had been a forgery which started the whole thing off. And you can see, just picking it up from what was held, page 1491, the second paragraph, 1491, held one, that registration under the Land Transfer Act 1952 conferred upon the second respondents as the registered proprietor a title to the interest in respect of which the appellant was registered, which under sections 62 and 63 was immune from adverse claims, other than those specifically accepted. That conception of indefeasibility being central to the system of registration. My Lord, section 63 was the same as in material respects as section 161. My Lord's page, if I can ask you to go to page 1501 first. Really, 1500, sorry. I think it's a speech of opinion of Lord Wilberforce.
Yes.
Roman para 2, he describes the effect of section 62. Section 63 is the one that is really important. You see halfway down against D, subsection 2 of section 63 is a particularly strong provision in its favour. It provides that the register is in every court of law to be an absolute bar. So you've got that same provision as you have in section 161. And then the uncertain ambit of these expressions has been limited by judicial decision to actual fraud. It is these sections which, together with those next referred to, confer upon the registered proprietor what has come to be called indefeasibility of title. The expression not used in the Act itself is a convenient description of the immunity from attack by adverse claim to the land or interest in respect of which he is registered, which a registered proprietor enjoys. This conception is central in the system of registration. It doesn't involve that the registered proprietor protects against any claim whatsoever. As will be seen, there are provisions and so forth. These are matters not required to be matters must be overlooked. But as registered proprietor, and while he remains such, no adverse claim, except as specifically admitted, may be brought against him.
I mean, the trouble with this is all fine and dandy, but we haven't got the relevant Act in front of us, and it much turns on what the Acts actually say, and as we've seen in all their sections.
Well, what in my submission this is saying is that what you see in section 161 should not be, if I can put it this way, be given a narrow construction. It is the provision which deals with indefeasibility of title. But, my Lords, can I just ask you to look at page 1503?
Yes.
The second paragraph, the effect of these provisions upon the claim of the appellant against second respondents, that's mortgagees, must now be considered. Doesn't admit of any doubt. It talks about a mortgage and fee simple. It is therefore apparent that the appellant's counterclaim against the second respondents, that's the mortgagee, insofar as it sought a declaration that the appellant's interest in land was not affected by the purported mortgage and a declaration that the mortgage was a nullity, was an action for recovery of land within the terms of section 63. I emphasise that, my Lords, because the question is what relief, substantively, is being claimed. And you can't get out of it by saying, well, I'm not seeking to object, I'm simply seeking a declaration, which will all come to the same thing.
Yeah, I see that.
Insofar as it's sought counsel, and so forth. And then, my Lords, I think over a couple of pages, the 1506, the final paragraph. The failure of the appeal against the second respondents as mortgagees entails that it must equally fail against the first respondent. But their lordships would add that the action against that respondent was an action for the recovery of land within section 63, and that it would be directly barred by that section, quite apart from the fact that it could not be maintained against other respondents. The appellant could not bring his case against the first respondent within any of the exceptions to that section. Also, their lordships would add that if it had been necessary for the first respondent to rely upon section 183, he would by it have had a complete answer to the claim. My Lord, section 183 is the same as section 163, I think, of the Jamaican statute. You can see it at page 1502.
Yes.
And I'm going to be coming to that in due course. But, my lords, what I submit one gets out of Fraser and Walker is you've got to look at the matter realistically and ask yourself, well, is what is going on in this action, is the respondent actually bringing an action for the recovery of land? And I submit plainly he is. And therefore I say section 161 bites.
Was there any equivalent to the proviso to section 70?
No. But, my lords, can I deal with the proviso point? Because in my submission, the proviso point doesn't help in relation to section 161. That is because... Sorry, my lord, forgive me.
No,
that is because section 161 says in terms that that no action can be brought against the person who holds a certificate of title to that land for ejection. In my submission, it follows from that that you have to read section 70 as subject to 161. Well, part of the problem with this case...
How then does the holder of that... How does the person in... If I've clocked up 12 years of adverse possession...
Yes.
...and you kick me out...
Let's say...
and I've got it against you, there's no question of a successor entitled
Yes.
How do I get possession back?
Under section 161E.
I see. But why can't that be true of the... against a successor?
Oh, because section 161E allows the action to be brought against A, the original owner, but it does not
allow... reference to
allow...
bona fide purchase of a value.
Yeah. And my lords, I submit, my lords, one says, oh, well, that all sounds a bit strange. In my submission, it's not remotely strange. I submit it is plain that once I've lost my title to a plot of land, my certificate is misleading. It's got the wrong parcels in it.
How does that work? Well, there are two questions. One is I've already put... Well, I think I put both to you. One is how does that... What does it... Section 88, therefore, doesn't add anything.
My lords, can I deal with section 88?
And the other was the 3-year tenant.
Well, my lords, I have to accept at the moment, I haven't thought of an answer to the 3-year tenant point. But, my lords, that, in my submission, the fact there's no answer to the 3-year, that I have thought of so far, to the 3-year tenant point, is not conclusive. The real, because it may be that the 3-year tenant would be able to say, well, the certificate of title is subject to my 3-year tenancy. Therefore, part of the problem, he doesn't need to get, in one sense, a 3-year tenancy. He probably doesn't need to get his title, he doesn't need to get into the register in the first place.
No, he doesn't, but how is he entitled to get possession? Because it's the opening words of section 161.
Well, my lords, whether that would qualify as an action for ejectment, it might be said the action by a 3-year tenant wouldn't qualify by necessary implication.
Ejectment is I've always understood, well, I'll have to check, but a tenant who's thrown out by his landlord does start an action for ejectment.
Well, my lords, I accept that. One might have to read section 161 as subject to an exception in favour of the 3-year tenant.
Is that the only reference to the 3-year tenant in the Act, as far as you know?
I think so, yes. It's the only time it's referred to.
Well, why not an exception in respect of limitation, then?
Because in respect of limitation, because, first of all, it's much more drastic, as it were, to impose it in relation to a bona fide purchase for value. Secondly, because section 161E can fairly be read as covering the situation of a certificate which has become misleading by virtue of adverse possession.
Well, what's the answer to my point that if that's right, then the proviso reference limitation is irrelevant?
Well, my lords, it may well be. My starting point is section 68 defeats section 70. You have to look at the rest of the Act to see what the proper construction is taking the two together. And section 70 should not be read as expanding what you see in section 68. It's a bad piece of drafting.
You're now on the bit of your argument which says we must look at the rest of the Act, and I was just wondering why the proviso is there at all.
Well,
on your case,
my lords, if you start from the assumption this is a brilliant piece of drafting and the proviso is supposed to trump section 68, I agree. I might be in some trouble. My point is, it's bad drafting all round. To divine the quote intention of the draftsman is a bit like asking to divine the intention of someone who doesn't know what he's doing. I mean, the fact is you've got to work it out on the words you've got. And by looking at the purpose of the Act. Looking at the purpose, most importantly.
Can you also help on section 88?
Yes. My lords, can I dig up section My Lord, I think it's at 776. My Lords, in my submission, this is not dealing. This is simply dealing with the position of any transfer. It's not dealing specifically with transfers bona fide for value.
No. It's saying the proprietor of land, omit words, etc., may transfer. And then, next sentence, upon the registration of the transfer, the estate of the proprietor set forth,
Yes.
blah, 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 with all rights, powers and privileges thereto belonging, shall pass to transferee, and transferee shall be, and whilst continuing such, shall be subject to and liable for all and every requirements and liabilities to which you would have been liable if you'd been the former proprietor.
Yes.
Now, if the former proprietor is liable to the rights of adverse possessors, why doesn't that apply to a subsequent proprietor under Section 88?
Because, my lords, this section is not intended to deal with the position of a bona fide purchase for value. It is dealing generally with transfers. Now, my lords, and transfers of all types as well, my lords. Part of the problem is we're focusing on one particular type of transfer in this case. But this, you look at the beginning of the section, proprietor of land or of a lease, mortgage and charge, or any estate and so on. What this is saying in my submission is this. Supposing I transfer my reversion to an assignee, then it's simply saying the assignee, who now has what was my reversion, is subject to all the same incidents as I was. It's not in my submission intending to say anything else than that. And I would go further, my lords, I would respectfully submit to say you'll be subject to the same requirements and liabilities is not, as Lord Jenkins himself admitted in Chisholm, is not a particularly elegant way or apposite way of referring to rights of adverse possession. The other problem in my respectful submission with that construction is this. If you look at the second sentence, beginning upon the registration of the transfer, the estate and interest of the proprietor as set forth in such instrument, or which he shall be entitled or able to dispose of under any power, with all rights and so forth, shall pass to the transferee. Well, my lords, that would appear to suggest that actually what the transferee gets is, in fact, what is shown on the certificate itself, rather than what's not shown on the certificate itself. So in my submission, one doesn't get very much out of Section 88. My first submission, in short, my lord, is this. It's not intended to cover this situation. It's talking about the standard provision about transfers of any interest in land, for instance, leases or anything like that, or mortgages. It's not directed at all to this. Secondly, it's plainly not directed towards, on the face of it, bona fide purchases for value. And this is obviously covering the position, for instance, of a transferee not for value.
I mean, we've made one or two submissions about purchases for value. We've got to assume that Section 88 is not covering them. But in contrast, as I understand it, we've got to assume that, although it doesn't say Section 88 is covering them, Section 68 is covering them. Well, isn't a more natural assumption that the provisions which are general are to be treated as general, and you're only dealing with bona fide purchase for value in rather limited specific situations where there's an express reference to purchase for value, e.g. the first part of Section 70.
Yes, or Section 163. I've yet to get to 163, which is very important.
Well, we have putting a lot of questions to you, but you are running into time. Because, one point I was going to make was, and I just ought to make it, you'll deal with it later, is given, on one view of what you're saying, there are two views to make of this muddle, as you might say, or inconsistencies. One is the one you put forward, the other is the one the Court of Appeal adopted. Ought not we go very strongly for the one against you, given that it has been so held to be right more than 50 years ago in a very clear decision of the Judicial Committee.
My lords, I will come
to go back. I know you are,
yeah.
But that's simply a point marker I wanted to put up. But you're dealing with a different point.
But my lord, can I just say why I submit the premise of the rest of the Act is quite clearly premised on. When you look at the drafting of the rest of the Act, in my submission, it is premised on the notion that when you've got a certificate of title, as bona fide purchaser, you win. You have a good certificate of title. And therefore you should read Section 70 as subject to Section 68. My lord, that is the whole of my submission. Can I just briefly run through the one or two provisions which I say make that good?
Yes, you want to look at 163, I think.
My lord, I'll come to that at the end. Can I start at Section 58?
58, yes.
58. It's simply the way the draftsman is expressing himself. 58, page 763. And this is on the question of what constitutes registration. And one can pick it up about 4 lines from the end of the page, 763. The person named in any certificate of title or instrument so registered as proprietor of or having any estate in or power over the land shall be deemed and taken to be the duly registered proprietor thereof. And that's a pretty odd way of describing things, if in fact he's got rights, that he's taking subject to any adverse rights. It's not conclusive, but one's trying to work out what is in the mind of the draftsman. My Lord, section 69 is my next point. This is a provision that requires a court, in an action for specific performance, to force upon a purchaser a title where the owner or the seller is able to produce his certificate of title. The certificate of title of such proprietor shall, if such proprietor is registered with an absolute title, be held to be conclusive evidence. He's got good and valid title. Yes. Oh, my Lord, that's an amazing thing to say. I mean, if this is right, if the argument against me is right, it could mean the court orders me to take this on the basis there's conclusive evidence that the vendor had good title. 2 years later, up pops the adverse possessor, which I didn't know anything about, and I've lost. Now, I submit section 69 makes no sense in a scheme where the rights are subject to, the rights of the vendor, the rights of the purchaser can be made subject to the previous adverse possessor. It doesn't make any sense. My Lords, moving on, section 130, or perhaps I should mention section 71, except in the case of fraud, no person contracting with and so forth need make any inquiries about any trust. Again, my Lords, if in fact the correct analysis is you ought to be very worried about adverse possessors, section 71 is rather misleading. My Lords, I'm conscious of the time. In our written case, my Lord, we do refer to an Australian decision which says section 71 is presupposing a sale to a purchaser and not a mere transfer.
What's the Australian?
It's called FCALP, I think. IAC.
Is that because of the reference to contracting?
Partly that, but also partly because it's talking about notice. The idea being you don't need, if you're transferring to a mere transferee, the concept of notice applies only to purchasers. It doesn't apply to mere transferees. That's the essence of it. So you read section 71 as covering purchasers. Again, in my submission, section 71 makes little sense in the context of prior rights binding the land. But, my Lords, it goes further. Take section 130.
Can we just go back to section 69? Sorry.
Yes.
But I see the force of your reliance on that. It talks about, in the first part, a person who may have contracted to purchase land not having notice of any fraud or other circumstances which, according to provisions of this Act, would affect the right of the vendor.
Yes.
Now, it might be said that if section 70 is given the meaning that is held against you, that, according to the Act, does give rights against the vendor, namely the rights of the person in adverse possession. And if you haven't had notice of that, then maybe section 69 wouldn't apply.
Well, no, in my submission on the proper construction, what section 69 is talking about is if I, the purchaser, have no notice of the rights, and assume for the moment I don't, if I have notice of the rights, I can obviously, as it were, put them up as an obstacle to the action for specific performance. Yes. But let's say I don't have. Let's say I genuinely don't have no idea about this. Then I obviously won't raise the point. The vendor then is in a position to show to the court. He may be acting in good faith because he doesn't realise what the position is. The vendor shows his certificate to the court, and boom, specific performance is ordered against me.
Yeah, but that's the same point as you made before, that if the purchase and sale are affected, subject to an adverse possession claim of which the purchaser is unaware, then the purchaser can seek damages from the vendor. Does section 69 take that point any further?
Yes, well, my Lord, he could, no doubt, but my Lord, that I submit it's an odd scheme of the Act to say
well, that comes back to that point. Yeah.
I accept your Lordship. One can always say, well, maybe there's an explanation, but the notion the draftsman is drafting all this against the background that the purchaser's rights can be defeated by the adverse possessor, I submit makes no sense. It's very unlikely he would have said anything like what you see in section 69. There'd have to be an exception. My Lord, can I go to section 130? I'm conscious of the time, my Lords. Section 130. Registration on transmission. My Lords, transmission is effectively, I showed you the definition at the beginning, it takes place where effectively something passes by will or by settlement. And what you can see in the second, well, it's a long paragraph. Can I just ask you to read the second sentence to yourself, beginning, upon such claim being proved to satisfaction, the registrar shall enter a memorandum of the change of proprietorship. There's a particular point I want to make on this and a related section. Now, my lords, the point I get out of this is this. Let's say there's an executor. The executor is deemed to be the transferee. He is simply deemed to be the proprietor thereof and holds the same subject to any qualifications that the deceased held it to. But the important point is the next bit. But for the purpose of any dealings therewith, under the provisions of this Act, he shall be deemed to be the absolute proprietor thereof. In other words, the executor, when he deals with the land, is deemed to be the absolute proprietor, i.e. he is able to sell free of any qualifications in the deceased's rights. And my lords, you get a similar...
Where do you get that last bit from?
Well, he shall be deemed to be the absolute proprietor. My lords, in other words, absolute proprietor, my lord, would have to be absolute proprietor of the land, i.e. without defect in title. There's no qualification in his title. So it's the contrast between being a proprietor. He takes as proprietor, but when he sells to a third party, he's deemed to be an absolute proprietor, notwithstanding any defects in his title.
I thought this business of absolute title and qualified title was what the registrar on first registration might choose. The referee might say, well, this is okay for absolute, or he might say this is qualified. In other words, I think these may be terms of art, Mr. Knott.
I'm just wondering whether they're defined.
Well, I don't know if absolute proprietor is defined. Proprietor certainly is defined.
25 is opposed it's absolute as opposed to qualified.
Absolute as opposed to qualified,
Section
yes.
25 on page 7.
Yes, well, but my lords, I still make the same point. He is in a different position. When he sells on as absolute proprietor.
But section 26B
Yes.
on page 747 says a person registered proprietor with absolute title, held its feet over all rights, blah, 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 be subject to such liabilities rights and under the provisions of this Act subsist over land.
Yes.
The operation of this Act. So it just brings you back to whether you're right or not.
Well, with an absolute title.
Yeah,
but
yes. That's what an absolute title means. It supports the point being made to it's merely a term of art, but I don't think it takes matters any further.
I accept your lordship's point, but again, I submit this is an odd way of drafting the statute. If in fact his ability to sell is subject to prior adverse rights. My lords, that really is the point I'm making. And my lords, a similar point arises out of section 138, which is at page 807.
Yeah.
Which has a similar contrast in the case of bankruptcy. My lords, I don't think I need to take you. It simply has the same point.
It's an absolute title again. Yeah. That's the point.
And my lords, finally, can I just ask you to look at on this point, section 146. This is the position of someone who is applying, a person proposing to deal for value with a proprietor.
Yeah.
This enables him effectively to put in an application which gives him priority for 48 hours. If you read 146 and 147 together, yes. he effectively has a priority.
Right,
and which means that if within that 48 hours someone lodges a caveat, then he still takes free of that caveat.
right.
Now, again, in my respectful submission, that would appear to suggest that supposing an adverse possessor within that period were to lodge a caveat, then, again, he would take free from that. My lords, all I'm submitting is that these sections, naturally read, presuppose that there is no prior claim. Sorry, that when you sell to a bona fide person of value, you don't.
They're all consistent with your point
Yeah.
that you look at the register and only at the register.
My Lords, can I deal very briefly with, I made my first submission in relation to section 161.
Chisholm, the basic argument against you on Chisholm is there are three possibilities. One is we're convinced you're right.
Yes.
The second is we're convinced you're wrong. It may be that Chisholm shouldn't stand in our way if we're convinced you're right. But let us say we think you may well be right, but the Act, as you have said more than once, is not a brilliant bit of drafting. There are two possible views here. Chisholm has said what the law is in very clear, careful terms. And after all this time, when Parliament's had, when the legislature had plenty of time to change the law, is it right for us simply to reverse Chisholm because we would have taken a different view on a point where a court could have gone either way?
My Lord, can I answer that point in a moment? I just want to, there are two other smaller arguments I made at first.
Fair enough.
The first is the point about notice. In my submission, if all that, on the face of it, all that the adverse possessor appears to have, if I'm wrong about section 161, is an interest under a trust. He doesn't seem to acquire legal title, because there's nothing in the Act that says he can actually bring an action for ejectment. If he doesn't acquire legal title, he holds as a beneficiary under a trust, and in my submission, the effect of section 71, at most, he would hold as beneficiary under trust. The effect of section 71 would be that the purchaser doesn't have to, as it were, inquire into. He's not bound by any trusts. But that's one argument.
But you recognise that as an alteration of the law, because the common law gave the adverse possessor a right
Indeed. Well, but if the adverse possessor has got no right to bring an action in ejectment, there's something that the Registration of Titles Act has made an automatic alteration to the common law.
Okay. So is that dependent on section 161 then?
No. That's if I'm wrong on 161. Supposing I'm wrong.
Sorry, that's what I meant.
Yeah.
Yes,
I say, well, look, the adverse possessor's got no rights to bring an action in damages.
I'm with you. Yes.
He hasn't got a right to bring an action in ejectment, and so on. So most he's got is an interest under a trust. Therefore, section 71, I'm free of it. Yes. But my third submission, in one sense, is the simplest submission of the law, and that's section 163, page 823. And in my respectful submission, it depends how you read this, but I respectfully submit the manifest intention of this section is to give the bona fide purchaser overriding protection, notwithstanding anything else in the Act. 163. Nothing in this Act contained shall be so interpreted as to leave subject to an action for the recovery of the land, or to an action for recovery of damages aforesaid, or for the deprivation of the estate or interest in respect of which is registered proprietor, any purchaser bona fide for valuable consideration of land under the operation of this Act. So on the face of it, my lords, just pausing there, I respectfully submit I'm a bona fide purchaser for value, and nothing in the Act, and that includes section 70, nothing in the Act exposes me to any action for recovery of the land or alteration of the estate. Just pausing there.
Well, but you can't pause.
No.
It goes on to tell you that it's fraud and error that it's talking about.
Well, no. In my respectful submission, it is talking about exactly what we have here as well. On the ground that the proprietor, through or under whom he claims, may have been registered as proprietor through fraud or error, or may have derived from or through a person registered as proprietor through fraud or error, and this whether such fraud or error shall consist in wrong description of boundaries, as I said it will, or of the parcel of land, my lords, all very importantly, or otherwise howsoever. Now, my lords, the question arises, which is this. You could, in my submission, what is, I imagine, said against me is, this is only talking about where the prior registration was wrongly obtained. In my submission, there's no warrant for reading the words so narrowly. This, and indeed, this applies where, at the time of the transfer to me, the prior registered proprietor had something on his certificate. He was registered in error as having something in his land at a time when he shouldn't have done. It comes back to the same point I made in relation to section 161.
Sorry to sound like a scratch record, but how does the 3-year tenant deal with section 163? Because it talks about recovery of land. You've got the 3-year tenant, the purchaser comes in and chucks him out, and he wants to recover the land.
Well, my lords, for the moment, I'm going to have to think about that, if I may. But on the face of it, my lord, section 163 could not be plainer in relation to adverse possessor.
Unless it's really saying this is subject to the rights of people under section 70, which are deemed, as it were, to be included as part of the rights which a person has, or rights to, subject to which a person takes or owns property when he's registered as a proprietor. And nothing in section 163 is dealing with that.
Well, my lords, in my respectful submission, that can't be right, because nothing in this Act And that must include section 70.
Isn't this, I mean, it's the same argument, isn't it, as the argument on the first part of section 70 and 161E. It all depends how widely you read the concepts of error and mistake and misdescription
It does.
and so on. And
it does.
whether there, as my lord says, subject to the proviso.
It does at least have this point, my lord, whereas you may say, well, the various points have been put to me in relation to section 161E. This talks about, or otherwise howsoever, at the end, right at the end. It doesn't matter how the error has come about. I am not, the bona fide purchaser is not to be subject to an action for recovery of land.
Well, it's whether it's fraud or error. And what I'm suggesting is really it isn't within section 163 at all, because it's all part and parcel of ownership, is that it's subject to easements, taxes, adverse possession rights and 3-year tenancies. And that's all part of the deal.
But an action for the easement wouldn't necessarily be an action for recovery of land.
I accept that, but all I'm saying is that all those rights, and the oddity is that there are two rights that involve possessing the land, and one of which involves owning the land.
Yes.
That's the oddity.
But, my lords, look at this section, if I may go back to my first point.
Because the easements all survive, don't they?
Yes, I'm bound to accept the easements survive.
But, as you say, section 161 and 163 don't present you with difficulties in relation to easements, because easements, except hypothesized, don't involve having possession or claiming ejectment.
Yes, but this covers actions for recovery of damages, doesn't it?
Yes.
So wouldn't it exclude, on your case, damages for breach of an easement?
It's damages as aforesaid. What is as aforesaid?
What does that mean? Wrongly deprived of land, so perhaps it's not. Or any interest in land. Isn't an easement an interest in land?
It certainly is.
It would be.
Well, so if you have your...
Well, it's interest in respect of which what are the damages referred to? Are they the damages?
162 is an action of damages.
Or any estate or interest in land.
Yeah.
So my lord's right, isn't he? That perhaps perhaps you'll deal with that question and the question of 3-year tenants that I keep on banging on about after the short adjournment.
Well, even if it's not a 3-year tenant, let's say it's a tenant who has got an interest registered in the register. Would 161 allow a lessee to kick out a lessor who had evicted him wrongly from his tenancy? On your interpretation, if we treat that no action for recovery of land against a person registered as proprietor can be raised other than those exceptions, how does a registered lessee get the land back? I think that has to be considered along with the 3-year tenant.
161F I don't think helps you, because that talks about a prior registration and it may be a later registration. So that's a bit I'm sorry, having given you quite a questioning time before the short adjournment, we've given you some questions to consider over the short adjournment.
I'll be as quick as I can, my lords. The substance of my argument, I hope, is plain, but...
Mr. Knox, you've been as plain and clear as you usually are. It's very helpful. Thank you. We'll resume again at 2 o'clock.